whether debt in possession or some other mechanism, wind income or any other mechanism. So the impact is felt differently dependent on where the insolvency is based. So if the company that's under insolvency is foreign, let's take Korea. Hanjin comes to mind. So it's a Korean insolvency process. Everything is maintained or monitored outside of Malaysia, but the vessel is to be arrested in Malaysia. I can say with almost absolute certainty the arrest would be allowed, because Malaysia is not a country that has adopted the UNCITRAL model law on cross-border insolvency. So a foreign insolvency process on its own, does not afford protection. A moratorium in Korea does not afford protection in Malaysia. An independent insolvency process must begin that gives local maritime a moratorium against proceedings. So that would be a foreign-based moratorium. What happens then if a company is actually governed by insolvency process in Malaysia? Would that impact on the right to commence proceedings? And that raises very interesting questions. You see, an arrest of a ship is not execution process. It's not your typical execution that's restrained by a moratorium. It's not against the company. It's against the asset itself. It's the res. It's against the ship. Having said all of that, finally, it's the company that's insolvent that has to spend the money to defend the arrest. So for all, in substance, it would be caught by a moratorium, a domestic moratorium, if the arrest is in Malaysia. Then the ultimate question would be, could the creditor who's wanting to arrest the ship get leave of court? Because the moratoriums are not absolute. They're subject to the insolvency court granting leave or permission to commence action. And that's where we would perhaps stop here on the tensions, that whether or not the court gives leave would be very, very interesting. The other point would be whether the secured status of a maritime claimant needs to be registered before it is recognized by the insolvency practitioner. And that we'll, I think, develop that as we go along, Clive. Yeah.
Thank you very much, Ms. Ifa, for that. Yes. That is indeed the underlying tension between bringing a claim against a vessel and ultimately having the owner of the vessel liable for the proceedings. Yes, the tension between in-rem and in-person claims. Can I ask Ms. Leong her view of the restraining orders and moratoriums and when they kick in Malaysia, just to take things off from Ms. Ifa's introduction.
Sorry, I was mute again. Yeah, sure, Clive, thank you. Yeah, so when does a moratorium or a restraining order kick in Malaysia? Basically, a restraining order and moratorium is pretty much the essence of it here is that if you get a restraining order or a moratorium, then the company is, the company is, it enables the company to be restrained from further, basically nobody can actually take action against the company, and the company is restrained from further proceedings in any action against it by except by leave of court. Yeah, and there's a provision for that in the acts as well. So in terms of restraining order or moratorium, they are pretty much essentially the same, except that maybe they're used in a little bit of a different context, right? For a restraining order, if the company is looking to embark on a scheme of arrangement or a compromise with its creditors, then I guess Section 368 of the Companies Act actually provides that a company can, upon application to the court, or even by any creditor for that matter, can also apply to the court for that company to obtain a restraining order. And the same provision of the Act also states that the restraining order may be granted by the court, may be granted, yeah? I mean, it's not absolute. It may be granted by court for not more than 3 months. And the court can actually, on application of the company, extend this period for no more than another 9 months upon further satisfaction of certain conditions, okay? So even though a company can apply for it, it doesn't mean that it's automatic. You have to apply, the court then decides whether it's going to grant it to you, and we grant it, it's only for 3 months. so that there's no abuse of the court process, because the court certainly won't grant a restraining order that will last forever, right? Because that it cannot be seen as an abuse of the court. Yeah. So even after the 3 months, if there is a further time required by the company to implement its scheme of compromise or arrangement, it has to go back to court every 3 months to get an extension of that order. Okay. Now, to get the extension of the order, and of course you can only extend it for another further 9 months. There are 4 very stringent conditions that the company needs to meet, and that's really pretty much set out in section 368 of the Companies Act as well. And these conditions are, for instance, right, the court has to be satisfied that there's actually a proposal for the scheme of arrangement, and the court also has to be satisfied that the restraining order is necessary to enable the company to
I think Ms. Leong's screen have hanged, the computer have hanged. Okay, I think whilst waiting for Ms. Leong to come back into the picture, can we ask perhaps Mr. Ravi to talk about the structure for rescue that Stage 3 might implement when you're in a maritime insolvency type of situation?
Thanks a lot, Clive. Great question. It's pity Meili was getting to the interesting stuff and she had to cut off there. But never mind. If I can match what she was saying with some degree of interest. I think I look at the participants. We've got people who are here which are very experienced. So I certainly want to see that we can actually talk a little bit about things that is of interest to them. Now, normally in terms of origination of the deal, it doesn't matter if it's particularly to the vessels or not the vessels, but I suppose where it comes when you think through how you structure the deal. I think most of the lawyers and people who have a legal background, I mean, the base case is what are the rights of creditors, and you look at what's the liquidation and look towards a structure there. But I think what's happening now more is that we've always sat back and said, look, let's look at the going concern value. What's the value of this thing as a going concern? And then see where all the various stakeholders match up against that value of the going concern, and that be secured creditors, unsecured creditors, or even the shareholders. Now, so that's the first thing, is you got to ask yourself, what does the post-restructuring balance sheet look like? And I think this is a very important point, because there's 2 ends of the spectrum, right? These are just some commercial things, but sometimes gets overlooked, right? It's no point, on one hand, people doing a scheme just to satisfy creditors and say, okay, we'll repay you all, but it's simply not possible. So there's an issue of sustainable debt, So it's what is actually sustainable and the cash flows, and you have to look at it carefully. And sometimes these are termed out for long periods. It's difficult. The other thing that you need to understand is, again, what type of instruments would match the certainty of the cash flow, right? A wonderful concession agreement, then it's pretty easy, right? When we did the government shipyard many years ago and they had a large defense contract, it's pretty easy to term it out because, the contract will come in. Other than, delivering risk, it's pretty good, right? But if you're, in a very volatile business, then I think perhaps the problem previously just had too much debt. That risk has to be now, reduced by equity, doing some debt to equity conversion. Then that's what it is. It has to be done. The other thing in the narrative that you have to really think about is, how do I get new money coming forward, right? That's a critical. So I think Sipa talked about the tensions between the insolvency law and company law. I would say there's also always these tensions between various parties, stakeholders, existing legacy credit capital and new capital as a tension, right? And that's something that comes into play and consideration. The actual working of the numbers are obviously fairly complex, and it takes a little more time to go through. But these are broadly the things that you would start thinking about when you start to put a structure to the deal. The other side of the coin is, okay, I mean, let's say it's, it's a large balance, $1 billion, and you say, okay, let's get it down to 200. Well, there's another balance that you have to find. So it's actually, dealing with the wants of various creditors. Yeah. For example, what you don't want is a situation where you do a restructuring, 2 weeks later, the white knight and the existing borrower sells it for a huge amount of money. Yeah. And the creditors who are rightfully, entitled to some of this, or at least commercially believe that they should have got the value, then feel shortchanged. So you can't come up with a scheme where creditors or any of the stakeholders feel shortchanged. So a lot about this is about, managing different stakeholders' wants. Yeah. I think, Clive, I think you get a little bit of what I'm trying to say here. The other thing that I would always say is, even before you structure anything, or before you get even to the first base, I always ask our clients and ourselves, what is your mindset? Yeah, if you haven't got the right mindset to do a large, complex restructuring. I mean, I'm not talking about obviously one ship, one vessel, and one bank type of situations here. Of course, we're talking about a large, complex where you like, I think Sitpa talked about 30 ships, and I think Mei Li also talked about 30 ships, and that kind of scenario. Yeah, we certainly got to think through. Have you got the mindset, to last out 18 to 24 months to see this through, right? And where again, I think where I can just echo where Sitpa comes, to do something as complex and difficult like this. Again, that's where the moratorium comes. You can't be fighting firefights every day with creditors. You need time to sit down, get the new business plan, talk to customers, etc., in a settled manner, right? If you can't, then it comes very difficult. I think I'll stop there, Clive. I'll stop there, Clive, and leave it there. But I hope that gives you some. It was a fairly complex question, but I hope it gives you some idea of the things that we look at when we try to structure the deal. Yeah.
Yeah, I was most intrigued when you said that it is best at the outside to get the mindset right, so that you're not fighting firefights every day, and you have a clear vision of where you want to go.
Yeah.
Okay. I now maybe while we're waiting for for Mei Li to come back, Ms. Sitpa, if I could ask you about you mentioned maritime claimants, and you mentioned briefly the 18 categories of claimants. I also think if you could explain to us briefly the legal requirements for a JM order, and perhaps how these creditors rank and in a scheme or a proposal.
With pleasure, Clive. So as I said, the JM mechanism has been very popular. I know it's not favored by Ravi, who prefers a debtor in possession. A JM necessarily means that there's a court overseeing this whole process. And therefore, insolvency practitioner goes in and takes over to a large extent, but it's for a finite period, 6 months, and possibly the outer limit is 12 months. There are stringent requirements, and what the courts have come out, the courts have been very busy. There have been many decisions on judicial management, and what the courts have been alert to is to the fact that parties and creditors must be vigilant that the judicial management route is not abused, because the benefit of it to the company that's insolvent is that you get an immediate moratorium against proceedings being brought against them, but it means the creditor, without real notice, have their hands tied. And so the courts have come out to say, look, you have to fulfill the statutory requirements, and this will be section 404 and 405 of our Companies Act 2016. Now, I'll just highlight the legal requirements, and hopefully we have Mei Li come in a little later to pad it out with the accounting, the real numbers and the strategy that works behind the law. But from the legal perspective, while a company or its creditor can move the court for a judicial management order, as long as there's a reasonable probability of rehabilitating the company, the court will only make an order if it is satisfied that one of the 3 objectives that's spelled out in section 405 of the Companies Act is likely to be achieved. So likely to be achieved are one of these 3 objectives, which is that the company will survive as a going concern at the end of the judicial management process. Is that likely to be achieved? Or 2, there will be a better realization under a judicial management as compared to a winding up regime. And 3rd, is there some chance of a restructuring under the 368, 366 route? So if only the court sees that there is a likelihood of that being achieved,
I think you're on mute.
have I been mute? Have I been mute?
Only the last few seconds.
Okay, sure. Yeah. I see Mei Li is in. Do you want to bring Mei Li in first? Then I can carry on.
Yes,
later.
yes. Miss, we were talking about sections 404 and 405. Sorry, you're on mute.
Yeah, sorry everyone. I'm so sorry.
No
the line was a bit unstable on my end. I was having problems trying to get back in. Okay. So anyway, back to restraining order and moratoriums. So in terms of a moratorium, it usually applies for a JM. So if a company applies for a judicial manager order to be granted by the court, then the very moment you file an application, the moratorium kicks in. Yeah, so that's the beauty of doing a judicial management, right? The moratorium then remains until such time the JM order expires or it's actually dismissed by a further application. Yeah. And during that moratorium, there's no resolution that can be passed to wind up the company. There is no enforcement of any charges that can be allowed or even repossession of property. And of course, there is also no other proceedings or legal processes that can be commenced against the company. So the company is actually preserved and it basically gives the company some sort of a stability, I would say legal stability to carry out its scheme of arrangement or some form of scheme, for it to work out its financial position. Okay. Then of course there's the moratorium that's granted if under the corporate voluntary administration. So where the corporate voluntary administration is concerned is a little bit different from the JM. And what happens is that when you actually apply for an application for a CVA, that moratorium also kicks in, but to get that moratorium itself, there are a couple of things that the company needs to do. When you file the application, there are a series of documents that needs to be submitted with the court as well. Like it has to have a document setting out the terms of the proposed voluntary arrangement, the statement of the company's affairs in relation to its assets, liabilities, creditors, and all that. And it has to have a statement that the company is also eligible for a moratorium, right? It's not like you just apply, but you have to justify why you need to have that moratorium. And of course, there's also one other thing. The company also needs to have a nominee statement. And the nominee statement is basically an insolvency practitioner giving consent to act as nominee, and that person would have to have full access to the company's documents and also be able to understand what the scheme is all about and present a statement disclosing the particulars of that scheme, so that the court can then justifiably grant that order for CVA to be undertaken and for the moratorium to kick in. In terms of JM and CVA itself, the Companies Act 2016 actually in the 8th schedule of the Act actually provides guidance on what is required for a company to be eligible for moratorium, the duration, extension of the moratorium, and all that. Yeah, so basically in a nutshell, a restraining order and a moratorium provides a legal stability and platform to the company to undertake a restructuring without having to fight battles with creditors trying to wind you up, secured creditors trying to repossess their assets or even take steps to seize their assets. Yeah. Okay.
Thank you very much for that. So I gather you have got a bit of breathing space once you have a judicial management order, some sort of restraining order.
Yeah.
Get the creditors off your back temporarily at least.
Yeah, that's right. That's right.
Yeah. I was wondering, Ms. Leong, whether you could elaborate on the challenges you face to maximize returns for stakeholders in the maritime industry.
Oh yeah, sure. Definitely. So in terms of maximizing returns to creditors, it really depends on what sort of what regime you're actually undertaking, right? If it's whether it's a receivership or in a JM. In a receivership, receivership is a lot simpler to initiate. It's normally a private appointment by a secured creditor. You've defaulted on a repayment, and if the secured creditor, usually a bank, has a debenture, it enforces the debenture and appoints a receiver. Okay, so in a receivership, is very straightforward. you take charge of the assets, and you sell the assets. Okay, so in a receivership situation, if you want to maximize the recovery or the returns to the creditors, usually the secured creditor, you act for the company as an agent, but you actually have a reporting responsibility to the secured creditor. And typically in a receivership itself, the key thing here is that if you have vessels in your as a charge assets, you got to determine where exactly what is the condition of the asset. Is it complete or incomplete? If it's a complete asset, well and good, you can actually advertise and find a buyer. But if it's incomplete, then if you try to sell it, right, you probably won't get the best value out of it, right? So typically what we have done here is that we quickly do an assessment as to what are the costs that would be involved to actually complete the vessel. If you're going to spend, say, 5 million to complete the vessel, and the realizable value of that vessel is 20 million, for instance, right, then it really makes sense to complete the vessel and sell it at a higher value, because in its incomplete state, you probably could only sell it as a scrap at value, right? Because nobody would want to buy an incomplete vessel for that matter. The other thing also is that what's the location of the asset? In one of the receivership jobs that I was actually handling, when we moved in as receiver, that vessel was stuck somewhere in Batam, right? So Batam is really no man's land. Your vessel is stuck there, right? You got to determine what is the value of the asset and how much does it take, right, for you to remove that asset, bring it back to Malaysian shores so that you can actually deal with it and sell with it. It was very tricky for us at that time. This was a foreign bank who had an exposure to this company. Sometimes you have to make a commercial decision here because we couldn't get access to the shipyard in Batam, so we couldn't really tell what is the value of that asset. So we took a punt. We made a concerted decision, and we said that, okay, fine, we will spend some money to remove it, bring it back to Malaysia, which we did. But unfortunately, the cost of bringing it back and paying off an unsecured creditor, because there were certain charges that needed to be paid to the shipyard, right? They're not going to release your assets if you don't pay them for some of the ship management fees that they've been that has kicked in, right? So we spent about over $1 million just to bring that vessel back, and unfortunately, we only managed to sell the vessel for less than 1 million, right? So, but unfortunately, I mean, it is what it is, right? Yeah. Then the other thing with the receivership, obviously, also is that if you have a vessel, and if the vessel is actually a operating vessel, where we were actually receiver of a ship chartering as a company, we were very lucky in this case that we managed to operate that vessel. There was a contract ongoing. There was a daily charter rate going. And we continued to extend that charter arrangement, and we were very successful in actually gaining some revenue from the operations and using the revenue to repay the bank whilst we attempted to sell it on a going concern basis. So we were also lucky there. Okay, but that's receivership. We are talking about JM, right? In a JM situation, maximizing return is not just maximizing return to the secured creditor. You also have to take care of the unsecured creditors. And in a JM, it's a totally different ballgame. The company is granted a JM order because there must be a chance of the company maintaining a going concern, right? The court would not grant a JM if there is no chance of the company if the company has got no going concern. So the whole essence of having a JM is that the going concern of the company must be preserved and is capable of being preserved to enable it to do a workout. So in a situation where if you're a judicial manager of a company, there is a need to actually ensure, right, that there are available contracts to work that asset so that monies can be generated, revenue can be generated to continue to pay OPEX, operational expenses. And of course, the other thing with the JM here is that it is also important for there to be new monies. Usually, you want to do a restructuring, and I think Ravi, my fellow distinguished panelists, will also opine to that. There must be management commitment to bring in new funds from the shareholders in particular, to also help the company to restructure, because the company may not have enough funds, and typically they don't, from operations to repay the borrowing. So these are some of the challenges. And on top of that, if the company is a going concern, there is also a need for the lenders to continue to avail funding for working capital purposes, because the company needs working capital to maintain operations. If it cannot support its own from its operating revenue, then it would be good if the lenders can also put in some money for the purposes of making the operations towards maintaining the operations, so that a larger holistic restructuring can be undertaken to steer the company out of its financial difficulties. Yeah, so this is something, some of the challenges that we've actually faced in running ongoing receiverships or JMs. Yeah.
Thank you, Ms. Leong. Mr. Ravi, following from that, when Ms. Leong mentioned that how you need new money usually in restructuring situations, can I ask what you think are the challenges that you face when you try and restructure a maritime company?
Okay, I think a lot of good stuff there discussed, Clive, by Meili, and in terms of new money, etc. I think one of the things that I can just share one overview comment. It's not necessary you need always new money, because some of it can be as just a straightforward restructuring of debt. If the company is generating sufficient cash flow, it's already possible, or just some debt to equity conversion. It's not always required, but it's a great thing to have new money for two reasons. One, it shows that there is people confident in the business. I mean, I can do any business plan I like show you, right? And again, the legacy, sometimes there's really no choice. And Meili talked about going concern. The reason why, especially in the maritime assets, the difference, and she alluded to it, is the difference between the vessel working and the realizable value today is so there's a difference which is so big. Yeah, it's very, very big. Yeah, it's huge, right? So your realizable value trying to sell a vessel is very, very small. So if you work them over a period of 4 to 5 years and you're given some runway on that, then you're going to get far better. So that that gap between going concern and liquidation is big. So the general view would be to try to go for a restructuring rather than selling it. And the reason for that is it's also one of the things that which we start talking a little bit is about the intangible value, right? And this is intangible value which is associated with the company. And if it doesn't show up in the books because it's actually goodwill. Yeah. So if you use a new cost structure and you buy the asset, then you do a valuation, you will actually see that that come up. And that's because the promoters have networks, their processes. Meili talked about contracts. I mean, the moment you go into winding up, and this one, it takes a lot of skill to keep those contracts in place, convincing the other party, the Petronas and so forth, to keep these contracts. They have licenses. All this is, and then just the way to run and manage the process with the software system, etc. All this have tremendous value as a going concern. Yeah. So the gap between a liquidation and a going concern is very, very big. Now, what I can say is one of the toughest parts, if you have made some promise on new monies, generally the rule is like this. Good practice is not the new money has to go into the business, right? That's the preferred approach. Not to pay legacy creditors. It's very, very hard to raise new money in a distressed business, right? Nobody, once everybody is trying to get out, you're trying to come in and put in new money, and that's even people like us, the professionals. We have been coming in for salvage. Even we have somewhat preference because everybody's running away, and you're coming in at this stage, right? So you need to be preferred. Now, it depends again on where the new money has come. We've seen quite a few ways it's coming in. Sometimes you're lucky, you've got a wealthy shareholder, yeah. He can bring in a listed company, he can pick up the placement, etc. At times, we've seen, obviously, in the earlier days, we had people like, the distress funds coming in. Asian crisis, there were quite a few, I think, which came in to actually buy voucher funds. If it was US dollars, we've seen that. And that's come in. Now, that kind of money would, of course, require very, very high levels of capital returns on the capital, anywhere between 15 to 25%. So again, to make those numbers work, the balance sheet has to be properly sized up, and the cash flow's got to match that, and so forth. So that would be the key one. Of course, existing promoters, they have the business, they understand it. The risks they see in the business is obviously lower. So again, they may not be as demanding. What we are seeing a lot more, and in the last couple of restructurings that we've seen, we've also seen cases where we've seen management and a white knight working together. We've seen two cases like this, management and white knight working together. And then the other thing that gives people ownership in the restructured companies management incentive program. We're seeing more and more of that being put in as that. So again, all this, there's no simple one answer to it. But like I said, where we see new money come in, and we've talked to the other bankers as well, very rarely do you see a failure to restructuring. It's probably one of the hardest parts. So if you have a condition precedent for the restructuring, that the new money has to come in, and these guys are only going to come in the last minute, right? When in all the the guys who are stuck, the legacy creditors, shareholders, all take their pain first, and they're completely satisfied that's all done. Yeah, they'll come in, and rightfully so, because in their view, why should I come in to rescue you guys unless there's something for me? I hope that gives you some flavor there, Clive, on the thinking that goes around with this. And again, I would share, it also comes back to the narrative that you're putting up, that gives confidence for people to come in. So you got to have a solid info memo with a value proposition if you're going for third-party new money.
Clive, perhaps I can just chip in here. Riding on what Meili and Ravi have said, they've flagged out three things. One is that you really need a firm proposal. You need the monies to be coming in, and you need to work the assets when it comes to a maritime company that's having vessels. Their best bet is to actually work them, generate income, and then turn around. So what the court looks for, and actually this has been often overlooked when they come for JM orders, is the court actually has a keen eye to seeing whether the proposal for the judicial manager to see through is at a very advanced stage. So it's not as if you can come with some whimsical framework and say we need a moratorium. It has to be far more than that. Backing that proposal, otherwise it's actually bordering on being an abuse. Backing that proposal should be an insolvency practitioner, your potential judicial manager's opinion, or in our language, affidavit, to say how he views the likelihood of achieving the objectives. Remember, I just spoke about the objectives being to get a better realization in the JM as opposed to winding up, or actually that you can survive as a going concern. So if his view is so important for the court to assess the likelihood of the objective being achieved before granting an order, a JM order. And then I come to what Ravi says, you work the assets. Now, this is where it becomes interesting. So there is a cutoff point, and Ravi put it as the legacy creditors and the new creditors. And quite often we forget that in judicial management. So if you look at the statute, it says that a secured creditor can oppose a judicial management. And an unsecured creditor seemingly doesn't have many rights, but there is a right under Section 425, which I want to highlight, because I just used it a couple of months ago, for an unsecured creditor to come in post-judicial management or during the course of judicial management. So what happens is that a vessel can be under charter party, and they could be straddling pre-JM and post-JM. So the pre-JM will go into some restructuring scheme. But as Ravi said, you need them to work for you. You need these vessels to help you generate and perform your Petronas contracts and so on. So you carry on. The JM carries on with these charter parties post the JM order being made. And those debts have to be paid. They are paid in priority. So when they are not paid in priority, that's when an unsecured creditor, post-JM, goes to court and says, look, this JM is prejudicial to me. This is unfair to me. And in Malaysia, we are different from England, where adoption of contracts in the UK, adoption of contracts by the JM is only employment contracts. In Malaysia, it is any contract. It includes a charter party. So the JM becomes personally liable for it. There becomes a priority of payment. So what I want to stress here, Clive, is that the cutoff date is so important. Once you've got a date, post-JM, then you are looking to pay everyone who's helping you generate income monies as they fall due. Otherwise, no one is going to be there helping you generate the money to turn around the company. And if it's pre-JM, then it depends on whether, and I think from the maritime creditors' perspective, they'd be interested to know whether they've become secured or are they unsecured and fall to be, generalized with everybody else. So if I can quickly say in the next minute or two, if there are special categories of maritime claimants known as maritime lien holders, which is if they have a collision claim, or if they are crew waiting for their payment of wages, or if there's a salvage operation debt that's outstanding, those would be clear secured creditors. Even if the vessel is sold, they can proceed against the vessel in the hands of the new owner. That's how secure.
Visitor, you're on mute. Sorry, last few seconds. Right.
Sorry. Yeah, sorry. So the maritime lien holders, they are secured. But if it's the other categories, remember we have 18 closed categories of maritime claimants, but for these 3 or 4, they're maritime liens, the others are statutory liens. If they have, so that can be, supplier of fuel, bunkers, ship repairers, any number of the suppliers of services or spare parts to the vessel, they would be statutory lien holders. And for them to become secured creditors, if they've commenced an action before the moratorium, well and good, they have got their status preserved. What happens to those who were about to, they have a claim, and it would be recognized as a statutory lien, but there's a bang-on moratorium that stops them from stops them from commencing an action. So I would suggest that they are actually secured creditors. They are like a floating charge, category of floating charge. They would crystallize as soon, they already have security, it crystallizes as soon as the writ is commenced, and they should be allowed leave to do that. So then they become secured creditors. And as Ravi and Meli say, look, if I need to work these vessels, I have to make sure that those who have the securities that could arrest this vessel are taken care of. If not, they're going to hinder me from carrying on and turning this company around. So it's very important, therefore, for the insolvency practitioner to bear in mind what categories are recognized as secured and therefore must be taken care of, so they're not a pain, they're not a thorn on your side as you turn around these companies.
Thank you very much, Ms. Sita, for rounding up on that. I thought perhaps as my last question, can I ask what your experience may be, each of you, your experience may be with fraud when it comes to insolvency and maritime related companies? Anyone?
Maybe I'll take that, Clive. I've not done fraud in terms of maritime, not quite yet. Perhaps something's brewing out there. But in terms of fraud, we certainly were involved. It's all this public knowledge. We were involved with a company which Megan Media, there was fraud. And I think I've also been involved as doing litigation support in terms of a company called Aldrich, where the bonds were issued. Yeah, and so we went quite in great deal with fraud. The thing about fraud is this: once there's fraud, it's actually very hard to restructure, honestly. Yeah. And for that purpose, I think the recovery comes more interesting in both those cases, which I talked about, against negligent parties. Yeah. Bigger portion of recovery. It's certainly restructuring becomes very difficult because there's actually no viable business to talk about. Maybe talked about going concern. I talked about going concern. Simpa talked about going concern. Really no going concern. Their business was stealing money, so we can't quite continue that business, right? So we just can't do that. So they don't really have a viable business. It is disappointing for, at least for firms like us, it's not really our business, but we're all trained. Felix and my partner, Derek's very, very involved in this. So then, it gets into this whole business of, let's go after the miscreants. Where do we get the money? Is it the directors? Sadly, it's the big four with the deep pockets, unfortunately, becoming more and more targets of this as well. And that's how the whole process works. So if there's fraud involved, it's very, very hard to do at least what I was suggesting, the Section 366 or the scheme of arrangement approach. That's perhaps sense word when you've got fraud involved. Yeah.
maybe I can also share on fraud itself. In the situation where we were the receiver of this company, which was actually a shipbuilding company, and this was the one where they had we had about 30 vessels at any one point in time, which we were managing. And some of the vessels were not complete, some were almost complete, but there was a lot of problems trying to complete it for various reasons, right? So in this situation where we had 2 vessels that went missing over a weekend, and when after we were appointed receivers, you see, the thing with fraud is that it is also very hard to prove. You know, at the back of the mind, yes, there's probably some fraudulent transactions that's happened in the past, right? But having enough documents on to actually pursue a case against the company and or its directors is actually very tricky, and it's not easy. And in this situation, the company had very bad records, and typically, and that's very typical in the receivership. You go into receivership, the records are in shambles. And here, the gentleman who's the director here, he is actually managing everything himself, right? He doesn't. His family members are all involved in the whole shipbuilding business, but everything sits with him. The hard drive and the soft drive, everything is in his head. He doesn't keep proper records. So we had that challenge. So what did we do in that situation? We had 2 vessels that had gone missing. So in this case, the bank actually decided to fund an action for us to pursue the recovery of this vessel all the way in Singapore. We actually had to take an action in Singapore. And the action went all the way to a discovery process. And the discovery process was very important for us and for the bank, not because we know that we're going to recover the vessel. We knew that it's not going to be, we knew that was going to be a dead end. We're not going to recover it. But what we wanted to do is to get to this stage of recovery where we can actually get the witnesses in to produce information and documents to be able to tell us what exactly happened with these 2 vessels, because we were able to track down these 2 vessels to a contract, you know, with a Middle Eastern party that was not complete, and that Middle Eastern party was the party behind this whole triggering of the vessel away from our shipyard in Klang to Singapore. So I mean, in that sense, I just wanted to share with everybody here that to try to uncover fraud is not easy. You know, usually you have to spend a lot of money, a lot of investment. And in this situation, we got the documents that we required. I think the next stage was for the bank later on to decide whether we want to go against the directors for breaches of fiduciary duty and some other actions that we can actually take against the directors. And this would be an action that the bank also I mean, this would be a support that the bank will have if they wanted to pursue other actions against the directors under the personal guarantee as well. Yeah, thanks, Clive.
Sure, no problems. Anybody else want to weigh in on the issue of fraud?
I just say a couple things. Of course, it's very, very difficult to prove fraud, but we have Hin Leong recently, not too far away from us, where it's not just the fact that it's a small company that's doing, stuff that against the line of business, but you've got a huge group of companies that have used that structure to be complicit, whether it's a warehouse suggesting inventory that's far beyond what they actually have, or vessel owners saying they're charter parties for movement of cargo that's not there. But it can be at that gravity or that scale of fraud. And to my mind, the better way then is to actually put the company into liquidation when it's that big. So like Meili's was carved out in a sense of 2 vessels being, surreptitiously moved out. But when it goes to the core of the business of the company, then perhaps the winding up is the better method, because then you have a whole host of provisions within the Companies Act that allow you to claw back assets for the liquidator to do it, of course financed by the creditors to claw it back, see what else has gone at undervalue for fraudulent trading. And fraudulent trading, even the creditors can bring the action personally against the officers who, with fraudulent intent, allowed the contracts or the debts to be incurred, knowing that there was no probability or there's a high risk that it would not be honored. So these are some of the provisions within the company structure, Companies Act, that allows for it, and fraudulent trading, if I'm not mistaken, Section 540 and so on. Yeah. All of that's prescribed, but it would mean, I think, when it's a systematic methodology of defrauding, whether by selling cargo that's not there, or selling and doubling back the cargo, or multiple sales of the same cargo, all of that happening, I think it's best to have the company go into liquidation rather than any of the JM. Yeah. You can't achieve any of this investigation within the time frame imposed under the JM regime or even under restructuring. That would be my take on that, Clive.
On that is out loud, because for sure it's out, because it's the directors who put the proposals up to creditors. If they're responsible for the fraud, who's going to achieve that? That's simply out of the window. Out of the window. But what I would also add to what SIPA knows, and we worked quite closely with SIPA's firm on this, is of course there are even more powerful provisions under CMSA. If it's a listed company or where bonds were issued, then it's a lot more interesting in terms of what can be done. And obviously there's been lots of successful action using the CMSA.
Yeah, I also agree with SIPA that winding up is always a good way of getting to the bottom of what actually happened in terms of past transactions, questionable ones especially. And the good thing about the Act is that the Act the powers of the liquidator provided under the Act is very, very wide, right? So because of that, the liquidator actually can do a lot of things, in terms of not just fraud, clawing back of assets, fraudulent trading, but again, must have documentation in place to be able to kickstart an action. Okay.
But I see one of the trends I actually see is, even when we were in Danahata, we paid for a very large case. That is obviously secret, I can't speak about it, but we actually did pay for investigations to enable recovery. And that's because, sometimes the banks we've already lost money. Do we want to fund another big action? It becomes a difficult decision, but we see more of that. And certainly after, it's very, very, what used to be in the 90s when I was in the UK normal, it's very much commonplace here now.
Thank you very much for that roundup on fraud. And I'm afraid I have come to the end of the questions that I have. I was trawling through the Q&A the questions that have been typed in by members of the audience, and I was wondering, I've got a question here that asks, to what extent does forum shopping factor into your decision making in maritime insolvency cases? Anyone would view? To what extent does forum shopping factor into your decision? I suppose forum shopping as to whether to arrest your vessels, maybe in one sense, whether to arrest your vessels in Malaysia, Singapore, Indonesia. To what extent does that factor into your decision making? Yeah.
Well, I can have a stab at that. Like if I look at what Hanjin was doing when they were when they managed to get their moratorium, when they were under some provision of restructuring in Korea, and it was quite notorious. There were vessels everywhere in the world and waiting outside, not coming into port limits or territorial limits, containers stacked on board and so on. And what seemed to be the flavor was to go to countries where they were able to register the moratorium, right? So, and where they could not register. So certainly Hanjin did not come to Malaysia. They managed to get a moratorium of sorts in Singapore, even though Singapore wasn't then on the model law yet. But they took their chance on that. So what would happen if I could bring in the forum shopping? To that extent, what the vessel would do to avoid an arrest was to go to safer havens which would protect them based on insolvent moratorium that they've got in another country, insolvency regime that would be recognized in a reciprocally by another country. That's one way that I think I understood the question to bring in forum shopping. Clive, not sure if that answers the question.
Thank you, Ms. Itpa. Anyone else would like to have a go on the question? Alternatively, the other question that we have is that the question from Singapore, when it says that in the new Restructuring and Insolvency Act in Singapore, there is a carve out for in rem rates in a winding up scenario. And the questioner was wondering whether there was a similar carve out under the Malaysian statute. And also there's a recent judgment in Singapore, I suppose, where in a JM situation, leave of court is not required to issue an in rem rate, but leave would be needed to progress the claim further. Would this be the situation in Malaysia as well?
Well, let me take that then. Let me try to take that. There isn't a carve out, but I am quite certain we would get leave if it's within a maritime lien or statutory lien, the 18 classes of closed claims. And that would be the same for the JM on the basis of some form of security and to be able to preserve that security. But that would be case law. I would derive support from the Australian cases. Justice Alsop had a few decisions, I think 2016, 2017, and that's what I would use to say that we could do it here in Malaysia, but no statutory cover.
Thank you very much. That's all the questions that I have, and those are all the questions that I have from the floor. So I want to thank everyone, especially our panelists, for your time today. Thank you for bearing with us on the 27th of July, and thank you for being here with us today again. And now I want to thank the participants as well. Thank you for tuning in. Thank you for staying the course, and thank you for signing in for this event. Yeah, I want to tell you thank you for putting up with us, most of all. And till we see each other again, I want to wish everyone goodbye. Thank you very much.
Thank you, everyone. Such a pleasure to be with all of you. Thank you.
Thanks, everyone.
Thank you. Bye.
Bye.
See you again.
Bye. Thank you very much. Bye-bye.
Thanks, Ravi.
Hey, thank you. I'm still here. Yes, thanks.
Yeah, thanks a lot for that. Sorry for the hiccup just now.
No,
my gosh, another.
No worries at all. Is Clive and all gone?
Yeah, I think they have. Yeah.
Okay, then
Yeah.
have a
Take care. Yeah, maybe we should catch up one of these days. When situation permits, we'll go and have a lunch.
I know the numbers have gone up in Malaysia, but you look at the trend in Selangor and KL, I think I can see a turn already.
You think so?
Yeah,
Okay.
RT numbers are not 106, right? But KL and Klang and the vaccination is at 40% second dose. That's the point you should start seeing something turning. But still, the ICU are obviously very, very full. So
yeah, I know. Still a worry.
Clear. But maybe the early signs of the turning is coming along. Yeah.
Yeah. Okay, we'll catch up.
Anyway, you just in our office anyway. Once we're back in,
exactly.
around the corner.
Yeah, I will grab you and Andrew.
All right. Yes.
Take care,
Bye.
Ravi. Bye-bye. Thanks a lot. Bye-bye. Okay, cheers. Yeah.